Pro-Vice-Chancellor, Lady Chief Justice, Professor Lockery, members of the law faculty, members of the MacDermott family in particular, distinguished guests. It's a real honour, both professionally and personally, to have been asked to deliver the Annual MacDermott lecture this evening. I will leave to my closing remarks the reason for the very personal pleasure I derive from this invitation to Belfast. In his inaugural lecture 50 years ago, Lord MacDermott emphasised the fact that the vitality and fortunes of a people are closely linked to the quality of their laws. He urged members of your legal community, and indeed the wider legal community, to scrutinise from time to time the health and condition of principal legal concepts with a view to safeguarding the common good. And it was precisely with this in mind that I chose the topic of tonight's lecture, although I must admit I didn't realise how close to an election I was going to deliver the speech. But it's a topic which, as you've seen over the last week, has captured many headlines. I refer, of course, to the speech of former President Barack Obama in Stanford University, where he addressed precisely this issue, disinformation and democracy, or indeed to the discussions which you've been following, no doubt, on the purchase of Twitter for $44 billion and what that will do to the public discourse and the public space. The Strasbourg Court has consistently held that democracy constitutes a fundamental element of the European public order. If we had lost sight of the fact that the maintenance and further realisation of human rights and fundamental freedoms are best ensured, on the one hand, by effective political democracy, and on the other hand, by a common, and I do underline common understanding and observance of human rights, then perhaps the tragic events unfolding in Ukraine since February have reminded us of the importance of what our forebearers have actually fought so hard for. In the words of the UK representative drafting the convention in a speech delivered in September 1949, and you know how central the UK was to that drafting process, the convention was to ensure that the states of the members of the Council of Europe are democratic and remain democratic. Over the last 2 decades, advances in information and communications technology have been critical to facilitating access to information and the free flow of ideas prior to and during elections. And few in our world would contest what the Strasbourg Court and national courts have often repeated. To quote Lord Stein, freedom of speech is the lifeblood of democracy. Few also would ignore the potential of the internet and social media to enhance its supply. However, it's now very well established in 2022 that state and non-state actors exploit technological advances to alter not just what information, but also how information reaches the electorate, and in some cases to interfere with democratic participation and access to information during electoral periods and well beyond. In a remarkably short space of time, a variety of new words have made their way into our democratic lexicon. You know them: fake news, junk news, disinformation, and the famous alternative facts. The Oxford English Dictionary Word of the Year in 2016, a year whose political significance doesn't have to be explained to this audience, was post-truth, which the dictionary defined as follows: relating to or denoting circumstances in which objective facts are less influential in shaping public opinion than appeals to emotion and personal belief. Commentators during the US election referred to lie machines, consisting of the governments and political campaigns that produce lies alongside the social media platforms, the algorithms and the bots which distribute them. And these machines don't just target individuals, but also, to quote a US commentator, they target the liberal epistemic order, political systems which place trust in essential custodians of factual authority, including science, journalists, public administration, and of course the justice system. In a 2019 Chatham House report, it emphasised that disinformation in elections is part of a much broader problem, and we saw this broader problem manifest itself during the COVID pandemic. It results from the spread of disinformation in day-to-day online discourse, and the effect, according to the Chatham House report, was to encourage tribalism and a polarisation of views on a wide range of issues, And this polarization, of course, feeds into voters' preferences in elections and into the tenor and content of political debate. So that's the context. What about the Convention? The Convention provides, now over 70 years old, in Article 3 of Protocol 1, that the high contracting parties undertake to hold free elections by secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of the legislature. And indeed, an Ulster academic, Rory O'Connell at Ulster University, has outlined electoral rights under the Convention in an extremely accessible way, if any of you are interested in his excellent book. Strasbourg Case Law covers a wide range of issues, not least what constitutes a legislative body, Convention compliance of conditions of access to voting, the organisation of elections or election campaigns, and the processing of electoral results. And most of our cases, I should stress, have not been as controversial as Hurst against the United Kingdom on prisoner voting rights. Most of them have proved absolutely essential to protecting what in this day and age has become a remarkably undervalued right, integral to the peaceful coexistence at European level of democratic societies based on the rule of law. On my taxi journey from the international airport into Belfast city centre, my taxi driver revealed to me that he would not be voting in the election, and I had to hold myself back as someone who left the island of Ireland aged 20 after I had completed my undergraduate degree and went to study abroad, and from that day onwards lost my right to vote. I have never had the right to vote in a general election since then. I think I was lucky enough to vote for the Treaty of Amsterdam in a referendum in Dublin, but that's all. So he was lucky he didn't get talking to. What is striking about the cases in this particular field in Strasbourg is that one still finds few, if any, reference in the case law to words like digital, technology, electronic, internet, or social media in Strasbourg Case Law on free elections. The votes and elections which have been the subject of the case law of my court to date have been votes which have been cast physically in elections, organised in bricks and mortar polling stations, after election campaigns which have followed very traditional lines and have been subject to very traditional rules on spending caps or on campaigning in the physical vicinity of a polling station or in the hours and days before voting. But look at the US election, the recent French election, or closer to home at recent referenda in the two parts of this island, and we know that this is no longer the principal, if not the predominant way, in which the people's approval is sought or acquired nowadays. So I propose this evening to provide you with a brief overview of Strasbourg Case Law on free elections and the closely related case law on Article 10 on political and free speech generally. Thereafter, it becomes a little bit more delicate. Like any sitting judge, and I'm sure the Lady Chief Justice will appreciate this in particular, asked to give a public address, I have to balance my own vow of discretion with your understandable desire not to be bored stiff for the next 45 minutes. And in a speech on law and politics, particularly one delivered a few days before a local election, it's a delicate balance. But what I propose to do is to ask whether and where there may be gaps in the existing case law in Strasbourg when it comes to the types of electoral and expression questions which now arise, and to question whether some of the underlying philosophy in our case law is ripe for some reconsideration. Starting with the interplay between freedom of expression and the right to free elections, the Court has consistently held that there's little scope under Article 10, paragraph 2 for restrictions on political expression. It has generally allowed states only a narrow, indeed a very narrow, margin of appreciation in this field, and this is because, of course, the particular importance that the Convention and contracting parties attach to free political debate. The interplay between expression rights guaranteed under Article 10 and those under Article 3 of Protocol 1 was summed up in a Belgian case from the 1980s called Mathieu Maïn, and in that case what was at issue was the complex system of governance which was set up in Belgium to accommodate the coexistence of three different linguistic communities in Belgium. And in the case, the Court emphasised the basic premise, which it has repeated for decades, in case law spanning 47 different member states, as you know, now 46 member states, and numerous electoral disputes. it said that free elections and freedom of expression, particularly freedom of political debate, together form the bedrock of any democratic system. Between these two interrelated articles, however, one finds a fundamental distinction. The narrow margin of appreciation, which generally applies to political expression, contrasts with the wider margin which prevails as regards the right to free elections. And this wider margin in the electoral field is understandable. For the purposes of Article 3 of Protocol Number 1, the Court assesses electoral systems in the light of the political evolution of the country concerned. It recognises that features that would be unacceptable in the context of one system may be justified or even necessary in the context of another. And a very good example of how the margin of appreciation operates with reference to local history, experience, and the domestic context in the electoral field is actually provided in a case from Northern Ireland called Lindsay against the United Kingdom. There, the European Commission of Human Rights examined and upheld the legitimacy of adopting a different voting system for Northern Ireland to that pertaining in the rest of the United Kingdom. And if you read the judgment, you see very clearly the Convention does not impose any particular type of electoral system. As per paragraph 61 of the much criticised Hearst case, each state is free to adopt legislation in the matter in accordance with historical, development, cultural diversity and political thought within Europe, which it is for each state to mould into their own democratic vision. The Commission in the Lindsay case held that the choice of a system taking into account the specific situation as the majority and minority existing in Northern Ireland must be seen as making it easier for the people to express its opinion freely. Another reason for the difference between the approach to Article 3 of Protocol 1 and Article 10 is that the former is not just about the protection of individual rights. It's also about the protection of the integrity of the electoral system within which individual rights are exercised. As the Court has recognised in its case law, since the Belgian case I just cited, electoral systems seek to fulfil objectives which are sometimes scarcely compatible with each other. On the one hand, they seek to reflect fairly and faithfully the opinions of the people, and on the other, they seek to channel currents of thought so as to promote the emergence of a sufficiently clear and coherent political will, something which I imagine this community is very familiar with. The requirement under the Convention that the provision is made for free elections thus implies, apart from freedom of expression, the principle of equality of treatment of all citizens in the exercise of their right to vote. Most member states of the Council of Europe have rules on paid political advertising. Their aim is to maintain the integrity, fairness, and legitimacy of the electoral process and the electoral outcome, and to guard against the possibility that private interests and powerful minorities can control those outcomes. Until now, these rules have tended to be scattered across different forms of legislation: election laws, broadcasting laws, and self-regulatory codes. Spending limits, pre-poll blackouts, and rules on political advertising have been some of the tools used by these statutory regulations. Two contrasting cases, both of which actually originated in the United Kingdom, are illustrative of how and in what context the Convention approach to political speech and campaigning has developed, and of the interplay between Article 10 and Article 3 of Protocol 1. The applicant in the first case, Bowman against the United Kingdom, was the executive director of SPUC, and she arranged to have some 1.5 million leaflets distributed in different constituencies in support of pro-life candidates. As a result of this, she was charged with an offence under the Representation of the People Act, which prohibited expenditure above a certain limit by an unauthorised person during the period before an election. The court considered that it is particularly important in the period preceding an election that opinions and information, and I underline, of all kinds, are permitted to circulate freely. Nonetheless, it also recognised that in certain circumstances the two rights may come into conflict, and it accepted that in that pre-electoral period it may be necessary to place certain restrictions of a type which wouldn't normally be acceptable of freedom of expression. But in the Bowman case, the court held that the relevant provision of the UK statute operated for all practical purposes as a total barrier to the applicant publishing what was factually accurate information with a view to influencing the voters, and it therefore found a violation. But fast forward a few years, and we see the landscape changing. The second judgment of interest dates from 2013, and I'm sure some of you are familiar with it. It's called Animal Defenders International against the United Kingdom. In this case, an NGO was refused permission to place a TV advert as part of a campaign concerning the treatment of primates. This was due to a statutory prohibition of political advertising whose aim was to maintain impartiality in the broadcast media and to prevent powerful groups from buying influence through airtime. The decision of the British Regulatory Authority to refuse to clear the advert had been upheld not just by the High Court but also by the House of Lords. The House of Lords held in 2008 that the statutory prohibition was justified by the aim of preventing government and its policies from being distorted by the highest spender. So how would Strasbourg react, given its decision in the Bowman case, given also its dislike, as you know, of blanket bans and previous Article 10 case law, where it had found violations in somewhat similar circumstances? When determining the proportionality of this general legislative measure, the Court and animal defenders attached considerable weight to the fact that the complex regulatory regime chosen to give political broadcasting in the UK had been subjected to exacting and pertinent reviews both by Parliament and by the courts. The disputed legislation, according to the Strasbourg Court, was the culmination of an exceptional examination of the cultural, political and legal aspects of the prohibition. The court found no violation in the animal defenders case, albeit it was split 9-8. The case raised a question which has, however, worried courts then and worries courts to this day, and it divides commentators: the proper role of courts as overseers of democratic procedure. Speaking as an international court with what is uncontestably a subsidiary and external role, the Strasbourg Court and Animal Defenders located the most appropriate place for the necessary balancing to occur at national parliamentary and, if necessary, national judicial level, on condition, of course, that the review carried out by Parliament and or by the courts was of a certain quality. Apart from this important expression of subsidiarity and respect for parliamentary processes, which one finds in this Grand Chamber judgment, and of course as a Strasbourg judge, I should mention that when I read academic articles criticising Strasbourg, or of course you have undergoing an independent review of the Human Rights Act, one does tend to look to animal defenders as a case which responds to those who argue that subsidiarity and parliamentary processes aren't sufficiently respected. Another aspect of animal defenders, which I think is particularly pertinent for our discussion this evening, is the fact that the impugned prohibition in this case applied only to paid political advertising, and it was confined to radio and television. Now remember, the House of Lords had handed down its judgment in 2008, the Strasbourg Court handed down its judgment in 2013. On the one hand, the targeted nature of this prohibition fed positively into the proportionality assessment carried out by the Strasbourg Court. But on the other hand, the applicant NGO had contested the rationale underlying the legislation because they said they considered it illogical given the comparative potency of new media such as the internet. Speaking in 2013, the court held as follows: notwithstanding the significant development of the internet and social media in recent years, there is no evidence of a sufficiently serious shift in the respective influences of the new and of the broadcast media in the UK to undermine the need for special measures for the latter. Oh, how things change, and how they change very, very fast. Before I end this brief overview, one final aspect of Article 10 case law is worth recalling. That provision recognises the essential role played by the press in a democratic society. The court has consistently held that the duty of the press is to impart information and ideas on all matters of public interest, and the public's right is to receive that information. Because of this, members of the broadcast and print media have been regarded as playing what we refer to as a vital public watchdog role. In this capacity, they are the recipients of a right which is granted heightened protection, but they are also bearers of important duties and responsibilities, something I'll come back to in a little bit. So if that's the basic case law to date, do we need to adapt the case law to our new digital world? When analysing restrictions on freedom of expression, the court follows, and the human rights lawyers amongst us will know this methodology very, very well. It follows a particular methodological path. Has there been an interference? Is that interference provided by law? And is it necessary in a democratic society? And in a case called Nkkp against Hungary, the Strasbourg Court got its first taste in 2020 of the use of new technologies, namely a mobile phone application, in the context of a political campaign. The case arose in the context of a referendum held in Hungary in 2016 in relation to the EU's migration relocation plan, which, as you know, was highly contested by the incumbent government. Just prior to the referendum, a small opposition party, Nkkp, which was against the referendum and whose platform was to encourage voters to spoil their ballots, it made available to voters a mobile phone application, allowing them to upload anonymously and share in real time, which I think is an important consideration, photographs of their ballot papers, preferably spoiled. So following complaints by a private individual to the National Election Commission, the applicant party was fined for infringing various principles of Hungarian law, handing down one of two rulings, but after the referendum had taken place, another relevant consideration. The Hungarian Supreme Court upheld the National Electoral Commission's main finding regarding the infringement of the Hungarian principle of the exercise of rights in accordance with their purpose. But the Supreme Court dismissed its conclusions regarding voting secrecy and the fairness of the referendum. The case came to Strasbourg, and by 16 votes to 1, the court found that the relevant provisions of Hungarian law, pursuant to which the injunction and a fine had been ordered, were neither sufficiently clear nor were they foreseeable. I think it's very important to stress that the Strasbourg Court took absolutely no position on whether ballot photographs could or should be legalized. Some of you may be aware that in the US there was some jurisprudence on ballot selfies, where people took selfies while they were voting, showing their ballot. The role of the Strasbourg Court isn't to take a position on a subject of that nature. Instead, what the court did was it enjoined Hungary, and indirectly other states, to provide for a clear regulatory framework in their regard, regardless of whether the state in question decided, fully within their own policy and margin of appreciation, to choose a permissive or a restrictive approach. The existing Hungarian legislation had allowed for the restriction of voting-related expressive conduct on a case-by-case basis, but conferring an extremely wide discretion on electoral bodies and afterwards on the domestic courts. But the National Electoral Commission and the courts had disagreed about the applicability of the very rules which the voters were meant to follow. In addition, while the National Election Commission had issued guidelines to the effect that the taking of ballot photographs was in breach of domestic law, those guidelines were held not to be legally binding. And, as indicated just before, the relevance and legal effects of these guidelines were only clarified after the referendum had actually taken place. Context was absolutely everything in the court's reasoning, because it said the electoral context takes on special significance given the importance of the integrity of the voting process in preserving the confidence of the electorate in democratic institutions. It's worth exploring further whether future cases on freedom of expression and elections in a digital age may put some of the basic tenets of the Strasbourg Case Law in Article 10 and Article 3 of Protocol 1 under increased pressure. Firstly, take the margin of appreciation, which states enjoy. As I explained previously, it's narrow when the expression involved is in the context of a political debate. It's narrow when the work of a political party is at issue. It's wide when what is at issue is the organisation and running of an electoral process, but it's also wide where there's an absence of what we call a European consensus, a tendency, a trend, an established body of law amongst the 47, now 46 states of the Council of Europe. But this means that where a complaint finds itself at the intersection between freedom of expression and free elections, the margin widens and narrows a little bit like an accordion. That type of flexibility is actually very important for an international, external, subsidiary mechanism like the Strasbourg Court. But of course, the risk is that it can lead to a degree of incoherence from one case to the next, a risk which we in Strasbourg must avoid. The second issue I'd raise is what constitutes a public watchdog within the meaning of Article 10. This concept has been changing as different and new forms of or under-regulated media emerge. The vital role of the print and broadcast media, which I mentioned before as public watchdogs in a democratic society, remains an absolute pillar in Strasbourg's case law on Article 10. However, in recent case law on the right to receive information under Article 10, the Court has highlighted the function of, and I'm going to quote, bloggers and popular users of the social media. It does sound like very old men and women writing judgments when you read it like that. And in this case on freedom, access to information, the Court held that they too may be assimilated to public watchdogs. And there's something very modern, very democratic in that approach. But it is potentially a major leap, and one which may have important ramifications in electoral contexts, because the individuals involved have not been subject to the same type or level of regulation as traditional media. And in a 2017 report entitled Information Disorder, the Council of Europe warned of the possibility of false or harmful information spreading amongst potential voters on an unprecedented scale, without any oversight or indeed any rebuttal. It's important to remember that the heightened protection afforded freedom of expression until now has always been offset by those duties and responsibilities that I referred to, which have lain on the shoulders of journalists. And Article 10, paragraph 2 is the only provision in the Convention which refers explicitly to duties and responsibilities. The third point I would raise is in relation to the nature of the legal obligations which Article 3 of Protocol 1 imposes on states. This article of the Convention doesn't lay down an obligation of non-interference. That's what happens with the majority of civil and political rights. It lays down an obligation of adoption by the state as the ultimate guarantor of pluralism, of positive measures to hold democratic elections to the legislature. The character of Article 3, Protocol 1 obligations has ramifications when Article 10 comes into play in an electoral context. It seems likely that we will in the future see more and more cases in which the Court emphasises that states have this positive obligation under Article 10 also to ensure that coverage is objective and compatible with the spirit of free elections, even in the absence of direct evidence of manipulation. A positive obligation approach means that legislatures need to strike the right balance between these two most important components of democracy and provide the necessary regulatory framework in order to allow the two components to thrive. The Hungarian case about the app which facilitated ballot sharing in real time suggests that this type of regulatory gap exists throughout many states in the Council of Europe in relation to freedom of expression and democratic processes. And as I mentioned before, the state's margin of appreciation in this particular field is particularly important. However, the margin of appreciation only comes into play when you're further on down the analysis. The Court, as I said, looks at whether there's an interference, then it looks at whether it's in accordance with law, and at that stage it looks at the qualities of the law. If that is lacking, the analysis stops there and there is a violation. The margin only enters into the game, if you like, at the level of justification, legitimate aims and proportionality. Another point, I think, which emerges from the Hungarian case is that the integrity of electoral systems may be undermined not just by the content of messages, but also by the nature of the media via which a message is being conveyed. The established electoral rules in Hungary clearly prohibited campaigning in the vicinity of polling stations. Yet the impugned mobile phone application was designed and made available as a campaign tool, and it could operate within the polling booths themselves as the election was ongoing. So a form of digital political campaigning simply escaped the existing legislation that existed at that time. However much political parties are still prepared to pay for TV and radio advertisements, it is really difficult to conceive in 2022 that the European Court, or indeed national courts for that matter, would reiterate that statement I read out from Animal Defenders in 2013, referring to the predominant place of television and radio broadcasting. Any of you present who have teenagers or young adults in your households will know that how they absorb news, the news that they absorb and the way in which they absorb it is entirely different to someone like me who is something of a political junkie and who will read very, very quickly several newspapers a day. A recent Russian case from 2020 called Engels concerned the removal by a website owner of information concerning filter bypassing tools to avoid his website being blocked by the Russian authorities. Now, this case demonstrates, in my view, very much how the conflicting realities of our pro-freedom of expression position, while beginning to realize the difficulties that the digital world is creating for us, it shows it quite clearly. In the case, the court found a violation of Article 10. The interference complained of was not prescribed by law, as the Russian legal framework simply failed to establish any relevant safeguards capable of protecting individuals from excessive and arbitrary interference. But the breadth of the legal provision on which the interference was based was also described by the court as exceptional and unparalleled. However, the court did say something which I found quite intriguing. It was a different section of the court, not my own. It considered, and I quote, "All information technologies, from the printing press to the internet, have been developed to store, retrieve, and process information and are content neutral. They are a means of storing and accessing content and cannot be equated with the content itself, whatever its legal status happens to be." Is it not worth pausing and reflecting whether this assimilation of new information technologies with a 15th century invention is really tenable? At the very least, it seems to me that there's a tension between data protection cases under Article 8 of the Convention and under the corresponding provisions of domestic law, where it is precisely the non-neutral impact of new technologies which is causing concern, and the presumption of content neutrality we find in this Article 10 case. One of the fault lines in the Animal Defenders case between the majority, the 9 majority, and the 8 dissenting judges was that the dissenters concentrated solely on the risk of political or electoral distortion coming from economic pressure being placed by wealthy individuals and groups directly on media organizations. And of course that risk exists to this day. Chatham House rules apply, so I can refer back to my introduction and the purchase of Twitter for $44 billion. However, would the focus nowadays, in a case like this, be also, if not more so, on the risk pinpointed, I think, beautifully by Lord Bingham in the House of Lords? And as ever, I'm a fan, he's worth citing at length. He wrote as follows: "It must be assumed that given time, the public will make a sound choice when, in the course of the democratic process, it has the right to choose. But it is highly desirable that the playing field of debate should be, so far as practicable, level. This is not achieved if well-endowed interests, which are not political parties, are able to use the power of the purse to give enhanced prominence to views which may be true or false, attractive to progressive minds or unattractive, beneficial or injurious. The risk is that objects which are essentially political may come to be accepted by the public, not because they are shown in public debate to be right, but because by dint of constant repetition, the public has been conditioned to accept them. This sort of one-sided information overload was treated with some skepticism by the Strasbourg dissenters in 2013. But I think it's something about which we have to engage very seriously, as Lord Bingham did, as far-sighted as Lord MacDermott, I would say, in his judgment in that case. The court's case law recognises that in the period preceding an election, information of all kinds, that was what the terms used in the Bowman against the United Kingdom judgment, Information of all kinds must be permitted to circulate freely. And in a Ukrainian case from 2005, Salov, you see the court holding true to this philosophy. Article 10 of the Convention as such does not prohibit discussion or dissemination of information received even if it is strongly suspected that this information might not be truthful. Where does this inclusive, indeed permissive approach in relation to political speech leave us in terms of disinformation and the speed with which the latter can spread throughout our digital world? And I think the balance increasingly reflected in recent case law is between the interest of participants, all participants in election campaigns, in being able to use every means possible to influence voters, and the right of candidates and voters to be protected from disinformation. We're seeing more emphasis in recent cases, Polish cases in particular, on the duties and responsibilities expressly referred to in Article 10, paragraph 2, and on the duties of the press to report in a diligent manner and on the basis of facts. In these recent Polish cases, the court has emphasized the need to combat the dissemination of false information in relation to candidates in order to preserve the quality of public debate. And the factual basis for the information should be precise, credible, and the journalists have to demonstrate that they acted with due diligence. My UK colleague, Judge Tim Ike, in a recent speech in Durham University, has also pointed to another possibly relevant provision in the Strasbourg toolbox. This is a word which is very fashionable nowadays, namely Article 17. Article 17 is one of what we call our nuclear options, because basically it is a provision which is aimed at ensuring that a person or group of persons can't attempt to rely on rights enshrined in the Convention in relation to activities aimed at destroying those very rights. But Article 17 is relied on only on an exceptional basis and in somewhat extreme cases. But it remains to be seen whether in this sphere we may see it being referred to more often. I return to the issue I highlighted before, the need for clear and accessible regulations which are suited to these conflicting realities of expression and elections in our digital age. And the challenge for lawmakers, because I am pointing a lot of responsibility on lawmakers, is not an easy one. Examining legislation from France and Italy which seeks to counteract disinformation, the UN Special Rapporteur has warned, and I quote, "Vague prohibitions of disinformation can effectively empower government officials with the ability to determine the truthfulness or falsity of content in the public and political domain, in conflict with the requirements of necessity and proportionality." The invasion of Ukraine and restrictive measures adopted at EU and national level might entail a leap in how we approach, on the one hand, the interrelated nature of democracy and expression, and on the other, what we may be willing to accept in terms of restrictions of certain forms of expression and content. On the first point, as a Strasbourg judge, and the court retains residual jurisdiction in relation to Russia until the 16th of September 2022, although it's no longer a member of the Council of Europe, I won't delve into the details of recently adopted Russian legislation criminalizing what is treated as fake news in relation to the invasion of Ukraine. You will have read a lot about it. However, I can say that those familiar with Strasbourg case law on Russian regulatory restrictions on speech and elections will not have been excessively surprised by the new criminalizing provisions. On the second point, the terms of the EU regulation and decision from the 1st of March 2022 adopting restrictive measures in view of Russia's actions destabilizing the situation in Ukraine are really very stark. The restrictive measures adopted by the EU and seek to counter hybrid threats, including disinformation. And the Council, in its regulation, it doesn't mince its words. It says the Russian Federation has engaged in a systematic international campaign of media manipulation and distortion of facts in order to enhance its strategy of destabilization of its neighboring countries, of the Union and its member states. In particular, propaganda has repeatedly and consistently targeted European political parties, especially during election periods. Now, I'm quoting from a regulation. I'm not giving my own view. And in any event, these restrictive measures would, as you can understand, be destined for the Luxembourg Court rather than immediately or directly be destined for the Strasbourg Court. But of course, I'm simply quoting the regulation. The regulation and the accompanying decision suspended the broadcasting activities of certain media outlets in the EU. And suspending a broadcasting activity or withdrawing a broadcasting license is pretty much the most severe interference that you can come across. Yet just a few weeks ago, the Strasbourg Court found no violation of Article 10 following the revocation of a broadcasting license in Moldova due to the media outlet's repeated refusal to abide by rules seeking to preserve political pluralism. And I will leave it to you to read the judgment to understand the precise geopolitical context of the case. The mention of Moldova is the hint. If nothing else, this recent judgment suggests that complete bans on providers of disinformation will always be very difficult to defend, but they cannot, in certain circumstances, be ruled out as impossible. And as the European political landscape changes, lawmakers and courts are simply seeking to respond to those changes while also safeguarding both electoral rights and rights of expression. And the challenge will be to ensure that counter-disinformation measures do not themselves have a prejudicial impact on human rights, freedom of expression, and democracy. I come to my concluding remarks, and I start again with a reference to Ukraine. I preside the section in which Ukraine sits, and as you can imagine, the conflict is very, very, very close to home, both in terms of my judicial work, but also in terms of the lives of the people with whom I work. And given the tragic and brutal events that we see unfolding on our doorstep, I was reminded by Lord MacDermott's warning in 1972 in his remarkably far-sighted article. He wrote, "The veneer of civilization is thicker in some places than others, but by and large, it is still woefully thin." Have we become complacent about democracy, about the value of our vote, as I wanted to tell the taxi driver, about the duty casting a vote entails, about the rule of law, referred to by Lord MacDermott 50 years ago, about individual rights, and about the need in certain circumstances to sacrifice or curtail those rights in the general interest? COVID taught us that we have. Democracy, the Strasbourg Court has repeatedly held throughout its 70-year tenure, constitutes a fundamental element of the European public order. In addition, the Court has repeatedly emphasized that one of the principal characteristics of democracy is the possibility it offers of resolving a country's problems through dialogue, without recourse to violence, even when they are irksome. And I think that's a point better understood in this community than in almost any other in the Council of Europe. It's important in my conclusion to restate the fundamental principle which runs through Strasbourg Case Law on Article 10 for decades. Freedom of political expression is a core value in any democratic state, and any restrictions upon it need to be justified carefully and fully. And none of the questions I'm raising or the alarm bells I'm gently sounding should be read as calling into question that fundamental premise. But the digital world is changing the nature and economy of political campaigns, of politics, and even of democracy as we know or as we knew it. Writing in the New York Times following the assault on the Capitol in January 2021, whoever thought they would witness that, Professor Shoshana Zuboff opened her analysis of what she considers the pressing challenge to democracy posed by surveillance capitalism, and she wrote in the following stark terms. 2 decades ago, the American government left democracy's front door open to California's fledgling internet companies, a cozy fire lit in welcome. The major data protection cases decided by national courts, by my court, and by the court in Luxembourg in recent years have focused on the potential intrusiveness of state surveillance measures and the abundant risks of abuse to which they may give rise. However, these risks should not blind us to other forms of surveillance which have developed, with us performing the role of paying, consenting consumers. If political democracy is the main virtue whose preservation has bestowed on freedom of expression its great value, it must surely follow that the preservation of democracy itself must be of equal, if not greater importance than freedom of expression. I put it to you that our legislation and our case law, and I speak also of the case law of the Strasbourg Court, whether national or European, will have to adapt further to accommodate the reality of 21st century elections, new forms of expressive activity, and the digital world in which we now live. I promised you I would end on a personal note, and I do. Though now a judge elected in respect of Ireland, and as a result of law, marriage and life in that order, a European to my very core, I'm also the granddaughter and daughter of Antrim folk. My grandparents, maternal, were headmistress and headmaster in Glenchesque School in Ballycastle in the Glens of Antrim. So your invitation to speak in Belfast was an invitation I leapt to accept. It has been a true honour to speak to you this evening, and a true honour to be here on the 50th anniversary of the first MacDermott Lecture. Thank you very much.